Welcome back to A Kid's Guide to America's Bill of Rights. I read you many of the sections or several sections from the First Amendment, and now I want to spend some time on some other critical amendments that I feel like you should know about. And one you hear a lot about is the Second Amendment, or people and guns. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. And infringed means shall not be trampled upon or regulated or that kind of thing. So, what you should know about this. With James Madison no longer around to explain himself, people have been arguing, sometimes in fiery terms, about these words ever since they were written. Lawyers and legal professors have usually taken what's known as the narrower view. The right to own guns is a collective one, and each state is allowed to protect itself effectively with a specific militia. Guns should be strictly controlled within the general population. Laws elsewhere. No one in the world are citizens as free to own guns as in the United States. It is the only industrial nation where gun possession is widespread. In 2011, guns killed 146 people in Britain, 58 people in Japan, and 188 people in Australia. That same year, guns killed 32,000 people in the United States. The majority of the general population, however, feels exactly the opposite. They already have guns and don't want them taken away. They believe the Second Amendment protects the right of individual citizens to own and use guns for personal safety and political freedom. This is possibly the most controversial amendment in the whole Bill of Rights. Nearly everyone who reads it interprets to suit his or her own philosophy. So now, on to the Fourth Amendment, or searching and seizing. So, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So Britain had practiced this a lot against the colonists of just randomly searching people, and the colonists decided to say enough. But it's really become a much more complicated issue, as you can see here. So these are some of the searches that James Madison probably did not foresee. Emails, computer files, cell phone conversations, blood tests, electronics eavesdropping, camera surveillance, trash cans, lists of movies rented, records of book checks out of the library, credit card transactions, medical history records, financial records from the IRS, patterns of heat detected inside a house with thermal imaging device, GPS from your car. So you can see that the Fourth Amendment and protections against search and seizure have become a lot more complicated. And elsewhere in the world, police in South Africa, France, Japan, and other countries have much broader powers to search and seize without a warrant. In the United Kingdom, the government's installed so many surveillance cameras that it's estimated that average Londoner shows up on film 300 times a day. In 1994, out of fear of crime, a decree was issued in Russia that gave police the power to search homes, offices, and cars without any evidence that a crime had been committed. They can also detain just about anyone they want for 30 days without charges. Police are allowed to go through the bank accounts of people suspected of crimes and even to investigate anyone who has lived with a suspected criminal for more than 5 years. This nearly absolute power of the often corrupt police has been a recurring theme throughout Russia's history. During its most repressive times, it has been the first step in programs that led to the death of millions. So the next few provisions have all sorts to do with the idea of justice and courts and criminals and so forth. And the Fifth Amendment in particular focuses on criminal justice. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. No person shall be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So, what does the Fifth Amendment really mean? The First Amendment protects your right to speak freely. This one protects your right to stay mute. When accused of a crime, you have the right to remain silent if you feel that something you might say could be used to convict you. No one can force you to incriminate or act as a witness against yourself. This provision is based on the idea that according to American law, you are innocent until proven guilty. This is not necessarily the case in other countries where the criminal code holds just the opposite, that you are guilty until proven innocent. In the United States, if you are charged with a crime, you're not required to prove your innocence. Instead, it's the government's responsibility to prove you are guilty beyond a reasonable doubt, of course. It has to do so without your help. Any confession from you must be purely voluntary. As much protection as the right to remain silent gives us, it's not always popular. Critics assume that it protects the guilty. If you won't talk freely, wouldn't it be because you have something to hide? The answer is that some believe that the price for the right is an occasional case where the guilty are set free. But the benefit is held to be greater. The innocent will not get punished. Now, what kind of game is double jeopardy? Another right protected by the Fifth Amendment is that you do not have to stand trial for the same charges more than once. If you did, it would be called double jeopardy. Why would this be so unpleasant? Because without this protection against double jeopardy, the government could try you over and over until it discovered a way to change an innocent verdict to a guilty one. Now, one of the most important outcomes of this right to not incriminate yourself is the Miranda warning, and you all know it. It surfaced sometime, I think, in the 1960s, and it's required of all police when they arrest you. The Miranda warning. When arresting a person, a police officer must formally recite the following 4 warnings and 2 questions. Number 1, you have the right to remain silent. Number 2, anything you say can be held against you in a court of law. Number 3, you have the right to talk to a lawyer and to have the lawyer present before and during questioning. Number 4, if you cannot afford to hire a lawyer, one will be appointed to represent you before and during questioning if you wish one. 5, do you understand each of these rights I have explained to you? Question mark 6, with these rights in mind, do you wish to talk or not talk to us now? Question mark. The Sixth Amendment is more about criminal justice. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Wow, that's a lot. So the Sixth Amendment gangs up a list of more the rights people have when they're accused of a crime. These are trial issues that fill in the background for things you've seen on TV. This amendment guarantees, for example, the right to a fast, public, and fair trial in criminal cases. You also have the right to confront witnesses, was another provision meant to thwart a basic unfairness. In order for a case to come to trial, there must be witnesses, evidence, or both. It isn't enough to tell a judge, everybody knows these people are drug dealers. Someone, either a citizen or police officer, has to confront the accused face to face at a trial. Now, here may be the most critical page of all for you people. These rights that have been stipulated are really the rights of adults, and minors have a different set of rights, and they were stipulated in the following Supreme Court case. According to the ruling in the Galt case, a juvenile who is accused of breaking the law has the following rights. Okay, kids, here you go. The right to remain silent, to have a lawyer present, to know what crime you committed, to have parents or guardian giving adequate notice of the accusation, to question witnesses, to confront the accuser, to have a prompt detention hearing, and to have an annual review hearing on an annual basis. So, there you go. There's the extent of your rights. The Seventh Amendment is all about making sure that people, if it's not a crime but a civil infraction, like if there's a dispute between two people, that the courts can settle it. And I wanted you to hear about the ways things used to be settled back in the day. Here's some of the ways disputes were settled before the Seventh Amendment. The blood feud, prevalent in early English history. If someone hurt or killed a member of a family, that family took revenge by hurting or killing someone from the killer's family. And then that family would take revenge and so on. The cycle would last for years until there was no one to remember the original case. The hue and cry from the same period. A villager went about town crying out, truthfully or not, that someone had wronged him. People of the village got together, found the accused person, and killed him or her on the spot. The cold water ordeal. In Old English law, accused people were tied up, thrown into a river. If they floated, they were guilty. If they drowned, they were innocent, though dead. Ordeal by fire. Wealthier accused people in the 13th century England would have to walk barefoot and blindfolded over red-hot pieces of iron. If their wounds healed quickly, they were innocent. Oath repeating. 12 of your friends would have to swear you were innocent, repeating a complex oath many times. If any of them made a mistake, it was considered a sign that you were guilty. Trial by battle. The accused would fight the accuser with fists or axes. They believed that God would spare the one who was telling the truth. You could hire someone to do your fighting for you. One judge listened to all the evidence and settled all the disputes, often according to his own whims or interests. So, as you can see, it's much better to have a civil trial to settle disputes like car accidents, property owners suing for money, patients suing doctors, people suing companies for bad products, victims of identity theft. It goes on and on. So, this is the last one I want to share with you, and it's a protection involving punishments. Excessive bail shall not be required, nor excessive fines imposed, and this is the critical one, nor cruel and unusual punishments inflicted. So check some of these out. For drunk driving in El Salvador, the first offense can be punished with execution by firing squad. In El Salvador, the first offense can be punished with, in Russia, the driver's license can be taken away for life. In Malaysia, the driver goes to jail. And if he's married, his wife goes to jail too. In South Africa, there's a 10-year prison sentence and or a $10,000 fine. And in Bulgaria, the second offense can lead to execution. Ouch. So check out some of these punishments elsewhere. Outside the United States, many countries without a Bill of Rights still use punishments that would be considered cruel, unusual, and barbaric here. In North Korea, public torture and execution of political prisoners is common. Prisoners who refuse to renounce their Christian faith can have molten iron poured over them. In Brunei, the punishments for rape, adultery, and homosexuality are public whipping, dismemberment, or death by stoning. In several Muslim countries, governed by strict Sharia law, punishment for theft is amputation of one or both hands. In Russia, those arrested for a wide range of crimes are routinely tortured and raped. Raped is sexually assaulted. In at least 2 countries, Saudi Arabia and Iran, punishments include being blinded. In Singapore, flogging with a cane is the punishment for vandalism, overstaying a tourist visa, and other crimes. In Saudi Arabia, some 100 people a year are publicly beheaded with a sword. So the big thing around cruel and unusual punishment in America has been the death penalty. Today, the fiercest debate about cruel and unusual punishment involves the death sentence. The death penalty or capital punishment is generally reserved for murder cases, and it has become the greatest challenge to the Eighth Amendment. Taking a human being's life is the ultimate punishment. Currently, 32 states allow it. Slow death would constitute cruel and unusual punishment, so American methods are intended to be quick. 2 states allow execution by hanging. 3 states use the gas chamber. 2 states, Oklahoma and Utah, still use a firing squad. The others use electrical chair or lethal injection of a heart-stopping chemical. Any of these methods can cause pain, and as humane as they may be intended to be, but is execution itself a cruel and unusual punishment? And that concludes our look at the key amendments in a kid's guide to America's Bill of Rights.